Hey, it's your old buddy Brian Parker doing another great video. This is one I promised I'd make. This is the application of a governing law provision. Now, that video I did, let's put that video up that I did in governing law. It got a lot of views and people liked it. It was a little complex and I was a little off the rails, but this is another edition of that, in that I want to show you what I told you in that video. When you are talking about using the governing law provision, it's your call to make. They've already filed in the wrong state. So you can just leave it alone, and it requires a little bit of research. So for example, I made the point of checking out the SOL, the statute of limitations. So if the statute of limitations favors you in the state you're in, we're not going to talk about, there goes a deer. We're not going to talk about the statute of limitations or the governing law in the context of whatever the governing law is from the creditor that's suing you. But if you look at the statute of limitations in the governing law of the contract and it favors you, you're talking all day long. So this is one of those cases. So I put up let's put it up, the governing law provision video. I'll leave that up there. Just go check that out. And then before I get started, go check out my 5-part series on analyzing a lawsuit and how you even go to the summons, which in some regards is part of the governing law. If they're stating, depending on your summons, like, hey man, it really belongs in the state, and hey man, it really doesn't. That's another thing that you can show the court of their misrepresentations. So that 5-part series is 8 minutes of video, I think. There it is up there. All 5 parts. Let's leave it up there a little bit. Okay, so the plaintiff in this case, I represented the mother and partially the son. The mother, I got the case dismissed. The plaintiff was SLS, Student Loan Solutions. I always laugh at the names that they call themselves. I mean, there's no solutions for any student loan for any defendant I've represented, but the mother and it's a common student loan situation. The mother or the aunt or the grandmother does the right thing in signing off on a debt, a private loan, for, let's say, to help their grandson or nephew or niece or son. And then things get bad, the economy goes bad, and the son can't pay. And now the grandparent, who's just living a lovely life in retirement, is now on the hook and they're getting sued. In this case, that was a similar case. My client's mother did the right thing and they sued her and they sued him. They went all in on my client mother, could not find him, and so they couldn't serve him with the lawsuit. I eventually got the case dismissed against the mother with prejudice, so she didn't pay anything. My client, the son, got served a lawsuit where he did not live, and they got a default for a large amount of money on this case. So he found out about that. He has some financial issues and he lives on friends' couches or places here and there, but he is doing the right thing with his mother. She has some issues, and so he's at home helping her in Miami. I say all that. They got a default against him in this case is an Orlando, Orange County case. And they told the court, they served my client who is in his 60s, bald, short, wears glasses, weighs 240 pounds. They didn't say more or less or from two. They just said, they must put him on a scale or something. 240 pounds and is Caucasian. My client, as I represented and showed the court with a picture of my client, is a tall, thin man with long flowing hair that he has a ponytail, has great eyesight, and lives with his mother in a county probably I've made that trip. It's 4 hours from where they're suing him, and he is Cuban American. So he is none of the things they say is, and the judge saw this right away, and we got a large default judgment set aside. But then they came back with a vengeance and they used the information to serve him in Miami, but they kept the case in Orange County, and that's why we're here today. So Let me put up what they said in their complaint. This is SLS, Student Loan Solutions, Shazam. And they're saying at least one of the defendants, they sued the mother and my client's son again. Now, oftentimes when you resue or reissue a summons on the same suit, you generally, I guess, leave the parties up there that were part of the case. Although, now I think about it, no, that's not true. If they're not being sued, they shouldn't be on there. The mother had been dismissed with prejudice. As you know, you can be dismissed with prejudice or without prejudice. If you dismiss without prejudice, you sit there for the statute of limitations waiting for them to refile it. But with prejudice, that case is gone. You can never be sued again. You can even take that and get it off your credit report because it's with prejudice, so you don't owe it anymore. So they said on, let's put it up if we don't already, at least one of the defendants resides in Orange County. There's only one defendant, that's my client, because the other defendant, who's his mother, no longer is in the case. So they're already within 2 paragraphs saying things they shouldn't be saying, and neither one of them lived in Orange County. They both live in the same place. So this is a lawsuit that is supported by your basic bill of sale. So just a quick reminder, SLS lawsuits, they're normally this old Bank of America debt from 2016 and 2017 that the SLS buys up and then pursues people for years to come, especially in Florida. And there's a point to my telling you. Here's the bill of sale that they rely upon, Shazamski, and that is relying upon the terms and conditions of a certain loan sale agreement. Well, if that's relying upon that, it must be produced next to the bill of sale. It wasn't. And it's also sold. All this bad debt is sold. I call it bad because you can see in the next 2 words, without recourse, meaning you take this, you can't sue us, this is as is, you can't do anything about it, no matter what happens, you're taking this for pennies on the dollar. So it has a problem already. Attached to the bill of sale is their proof. I won't go into the details of what attachments mean and what you must do evidentiarily to have that data form that I'm about to show included in the bill of sale. There it is, Shazam. I'm going to give you some time, pick up my client's name. You know, I redact everything so that I can use these cases without telling my... I've only had one client say, sure, go ahead, use my picture. It was a couple of videos ago. But look for my client's name. Go ahead. Tick-tock, tick-tock, tick-tock. That's right. So if you can't see it, nobody else can. It isn't there. So there's nothing proving my client is on this debt. But I want to show you why we are talking about the governing provision today. This is so cool. Let me put up the contract that my client and his mother signed. Shazam. All right. That's your basic. If you've been sued, Bank of America, SLS, you're familiar with this. In fact, you're familiar with this even with NCSLT cases. They use the same agreement from a lot of the banks, including Bank of America. I want to emphasize the part about co-signing and non-negotiable. Shazam. So here, this is where the governing law provision, I promise, is going to come in. A non-negotiable credit agreement. This is a consumer credit transaction. I point that out to you because now comes our analysis of whether is it better to have Florida law or California law. We know in this case that California is part of the governing law. Let me put it up there. I'm running ahead. I'll just put it up there now. It starts with additional agreements. Shazam. That's the governing law of the contract you just saw. I understand that you're located in California and the credit agreement will be entered in that same state in large letters. Consequently, the provisions of this credit agreement will be governed by federal law and the laws of the state of California without regard to conflict of law. So this was sued in Orange County, Florida. So our analysis is which is better. Remember I told you before you make the move or the motion, see which is better for you. I had this question of question and answer a couple of days ago. Someone said, I'm in Nevada, but it's a Utah provision of law. Which one do I use? And I tell you right now, what's best for you? because they don't care. They filed you in probably Clark County in Las Vegas, and their provision is Utah. So they're not doing the right thing. So go and check it out. If it benefits you being in Nevada, fine. If it doesn't, go to Utah. So under the federal law, the FDCPA, 15 USC 1692I, for you to sue someone in their properly, you must show that they are in that jurisdiction you're suing them. Jurisdiction meaning you're under the umbrella of the circuit court or district court. You belong in that district because you live in the area, right? Or you signed a contract when you signed that contract that you're being sued upon in that area at the time. In this case, as I've told you, my client lives in Miami, has done since probably 2010. The contract was signed in the place he lives in now in 2007. So put up 1692I, Shazam, and that says, in the case of an action not described for real estate, you can bring an action only in the judicial district or similar legal entity which the consumer signed the contract, in which the consumer resides at the commencement of the action. All right, so that's a good way to both win the case, win the jurisdiction argument, and also sue them. You got an FDCPA provision, and I'm sure in this case, this is Florida, they have a great state local action, FCCPA. So why am I telling you about the governing law provision? I told you about, let's put it up again, let's put up the governing law provision of this contract. See that? Now take it down. Now put up the statute of limitations in Florida on this type of debt. Shazam. It's 5 years. Under Florida statutes 95.112B provides a 5-year period. So we want to be in California, yes or no? What are the student loan, as I'm thinking of something really funny to say, it's the statute of limitations, but we want SLS to be governed by Florida or California. So let's look at the California statute for private student loans, Shazam. And you can see the California Code of Civil Procedure 337A provides the statute of limitations for actions based on a written contract is 4 years. See that? We found that the Florida law is worse for us, and we need California law here. I point out the fact that let me put this up again. Put up cosign, loan request credit agreement. Shazam, that's non-negotiable. If you have a promissory note, there are some states that say promissory note, 6-year statute of limitation. California has some of those tweaking, but this is a non-negotiable credit agreement, and California specifically says 4-year statute under those written terms. So that governing law is something we want to promote. We want that. Again, I give you this as an analysis of your particular case, of your particular state. Check out the SOL. So now we know we belong in California. My client has not made a payment on this in over 10 years. A quick pro tip. In most of these cases that are filed, especially in Florida, Bank of America sent out a letter to all these people that SLS sues a decade later, and they ask for full balance. They say, you owe all this, and then 2 years later they sell it to SLS. SLS in Florida comes in after the 5-year statute of limitation and sues the client anyway, because in Florida there's case law that says you must pay, the statute of limitations, starts once the person owning the debt makes a demand for full payment. So a lot of these cases you see the defendants have received a letter from a company, a debt collector called Williams and Fudge, asking for the full amount maybe a year before they were sued. My client will come back and go, hey, this is 10 years ago. I didn't make a payment on this. But the Florida case law is that No, the SOL starts on the day that they ask for the full amount. California, let's put what California says, all right? So that we are very clear about this. Do I have it for you? I'm messing you up, messing me up actually. So we want to put up the California Code of Civil Procedure, Shazam, and that says it's based on a written contract of 4 years from the date of the cause of action accrues, which is the date the debt is due or when a payment is missed. So California says it's when a payment is due or missed, that's when the statute starts. SLS is coming into Florida and suing whenever it wants on long ago, long dead, untimely filed lawsuits and saying, no, Florida law says if we send out a notice saying, where's all our money, even though the date of the missed payment is long gone, Florida law will recognize that as the beginning of the statute of limitations, and there's still another 4 years to go. So you want to be off to California we go. We don't want to be in Florida, because if they've made a demand for payment on the defendant that I'm representing, or you, just a year ago, on a debt that's long gone 10 years ago, they started the statute of limitations again, whether you like it or not. So there's ways to fight that. And Bank of America, as I said, sent out all these letters back in 2015 to people before it moved the debt to SLS. If you have one of those letters, they're a get out of jail card free, because the rule in Florida that brings you right back to the statute of limitations starting again says when full payment is asked for, that's when the statute. So Bank of America sent out a bunch of those letters in 2015. I know it's a hard sell, but you'd be surprised. They'd say 3 out of 4 of my clients kept those letters from 10 years ago, and we use those in defense of the case. My client has one of those letters, but California governing law is going to save him either way. I hope that makes sense. It must be that whenever I use the words governing law, I get all complex and elitist on you, if you will. But use your brain a little here. So now, do we file an answer or do we file a motion to dismiss? We've talked about this in the last couple of weeks. I'm on the fence, but I want this in front of the same judge that just saw that they filed this really bad description of my client to get a huge judgment against him. And she said, what, are you kidding me? And she turned it over. So she's got that good flavor in her mouth about us. So you'll read, if you read my motion, I'm going to attach it to this video. It says, these guys continue to bumble along, doing the wrong thing, blah, blah, blah. Be human in your description of what you want. Don't be all loyally and stuff. I'm going the opposite of elitist. Say they are bumblers, they are making misrepresentations, and just say out front what you want to do. So I went in on the motion to dismiss. I just filed it, and I'll attach it here. And even if you lose, which is unlikely because they clearly have sued my client in the wrong county, the reason why they didn't refile the county file it again in the right county, I think, because they knew they had statute of limitation problems already, and to refile it in a different circuit may make it even more obvious. So I wrote that in my motion saying, I think they did this purposely. So you've got an opportunity here. I've got a great counter affidavit attached to this motion along with 5 other exhibits. I'll attach the motion to dismiss, plus I'll throw in a motion to dismiss from a Michigan motion to dismiss. I've given you a couple. Again, these are all in Word templates, so you just drop your situation into these. I'll have the counter affidavit I filed in this SLS case, my show notes, everybody loves those, so you don't have to look at this face again. Just read the notes, instructions. I'll have a PDF of the actual motion I filed and all the exhibits and how I did it, just if you want, whatever. But I hope you get this here. The purpose of this video today is how do we juggle which governing law and why? We take a look at what benefits us. So we know there's a governing law provision said it belongs in X. You're in state Y. take a look. And if you don't say anything or don't file anything, you just stay where you're at, nobody's the wiser. Nobody's going to say to you, there's no rule that says, he didn't bring a motion for governing law. It's only something that you bring up, and you haven't done anything wrong because they filed in the wrong state to begin with. So they're not asking you to check on them, make sure they're doing the right thing. So I hope that makes sense. You may have to watch this and this again, but I hope this is mapped out for you, how important it is to just do a little bit of analysis, especially in your statute of limitation. Just Google it. And in this case, we're in a little deeper in that it's the time that a missed payment is missed in California. California has an extra oomph for you, whereas here, you can have a case that's well beyond the statute of limitations, but if they've sent you a letter and they're claiming they have, in my case, and I put it right in the counter affidavit, I put it right in the dismissal motion, they did not allege that a payment had been made or that letter had been sent out. I bring this to your attention because it's on them to do that. Because why else are they in this jurisdiction, wherever they are, on a 2007 debt? I think they're being a little spiteful, to be honest with you, and hoping he defaults again. Because it said clearly it's an Orange County case, yet they went all the way down to Miami and served him, which is 5 hours in a different county away. I don't think they liked that set aside, and they just keep coming back. My past dealings in the past with SLS, it's not a positive experience, and even in that default motion, I showed them a picture of my client compared to the 60-year-old that they claim, and they go, it's the same. It was just a typographical error, just a silly, some debt collectors get like this. So like, love, and subscribe. Let's go get these guys. I hope if you have a situation, this makes sense to you as far as, what's it called? The juggling of the equities? But it's a juggling of your options, okay? So go get them, go get SLS, go get them all. Thank you. Bye.